I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today we are talking New Jersey in a special quick reaction episode. On January 8th, 2024, New Jersey's legislature passed a comprehensive data protection law, and New Jersey now appears poised to be the 13th or maybe the 14th state, depending on how you count, with a comprehensive privacy law. Listeners of this podcast will immediately ask themselves, what does this mean for me and my organization? In particular, if I comply with California, Colorado, and other laws, do I have to do anything else to comply with New Jersey? Is there additional uplift that is needed? And so we're planning on doing this special episode quickly. Think of this as the quick hitter episode. Unlike on our other episodes where we've done deeper dives into subject areas, this one will just give us immediate impressions and let you leave this episode with what you need to know about New Jersey's new law. We'll save the longer discussion for our future episode, but to discuss this one, I am joined by my colleague, Harsimar Dhanoa, who is a member of our privacy practice here at Hogan. Harsimar has been on prior episodes, and I'm so happy to have him back on the program. Welcome, Harsimar.
Thanks, Scott. Really appreciate it, and happy to talk about New Jersey and what this might mean for 2024 more broadly.
Great. So, Harsimar, let's just start in, and I would need to maybe say at the outset is that I've now tried to read through the bill a couple of different times, and I'd say the first time that I read through it, I was confused on what bill I was actually reading. So maybe you can help the audience know where to actually see the proposed law and how to make sure that they're looking at the right version.
Yeah. So New Jersey is a special case because the bill started out much differently than what we see today. And if you were to go to the New Jersey website and try to look at the bill itself, you really need to skip about a third of the way down, because what the legislature did was strike out all of the old text that they had originally considered and then move to something that's closer to what other states have actually enacted.
Okay, got it. So key tip, go 1/3 of the way down, then start reading. In particular, start reading the language that is underlined in black as being the new dispositive language that has now been passed and presented to the governor. Is that right?
Exactly.
Mm-hmm. Okay. So, you mentioned that the bill now looks very similar to some of the other states. Can you kind of give us a quick overview of those similarities? Where do we see those key themes from prior state laws appearing now in New Jersey?
Yeah, so structurally, the bill is very similar to what we started seeing with Virginia, and then the same model was adopted by a bunch of other states. I would say across the country, it's probably the predominant model, California being sort of the main apple. You'll see things that are pretty consistent in terms of similar notice obligations, requirements to conduct data protection impact assessments, opt-in consent requirements for sensitive data, and similar individual rights across the board.
Got it. So if I'm thinking about this, then, for the most of the key items that have now appeared thematically in these laws, most of those issues will be replicated similarly to Virginia and kind of those other similar laws. And now maybe the key question is, what is different about New Jersey that may require some additional attention as organizations engage in any uplift with their state compliance programs?
Yeah, Scott, I think that's right. The good news is that businesses, organizations that have a compliance program in place, the bulk of the work is already done. But the devil's going to be in the details around some of the nuances and slight tweaks that you might need to make to handle some New Jersey specific requirements.
What are some examples of those unique New Jersey requirements?
So the one that comes to mind most clearly is around sensitive information. The definition tracks pretty closely to what other states do, but New Jersey in particular included financial information. And I think most people would think of financial information as being sensitive, but most states actually don't explicitly include it in the definition. California included some specific categories, things like a credit card number or debit card number, certain financial account numbers. But New Jersey takes it a step further and says that financial information, which, by the way, is not defined specifically, would also be treated as sensitive as well.
So that could be like payment card information or bank account numbers or things that organizations use in the ordinary course of operating an e-commerce site, for example, could now be considered sensitive information, essentially kind of subject to the same types of requirements as other sensitive information that individuals or companies may be more familiar with, like health information or biometric information, genetic data, and those types.
I think that's right, Scott.
Interesting. And I think I've been, as I've been reading this, there seems to be also some unique requirements relating to opt-in consents by minors.
I believe that's right. And so we've seen some states that have put in opt-in consent requirements for people who are between the ages of 13 to 16 around targeted advertising or the sale of personal data. New Jersey goes a bit further by saying that if you're going to be profiling as well for legal or similarly significant decisions, you're going to need opt-in consent as well. New Jersey isn't the first state to consider a requirement like that, but it's just highlighting that there's an increasing level of complexity, particularly if you're working with minors' data across the country.
Yeah. And, I think one of the other things that you pointed out in a blog that you wrote about this was that there was not the same type of articulation of some of the exemptions to the law. So, as we have worked with prior laws and worked with legislatures to make sure that organizations have clear rules that apply to them, these state laws often overlap with federal laws, things like FERPA and things like HIPAA and GLBA. It sounds like this law doesn't exempt FERPA expressly and also doesn't exempt data that's been de-identified in accordance with the HIPAA standard as being expressly exempt from these obligations.
That's right, Scott. And that creates an additional level of difficulty, both in terms of if it's FERPA related data that's being maintained on behalf of a school. Organizations are going to need to think about how exactly they're going to comply both with New Jersey's requirements as well as any requirements that the school entity might put on them as well. Similarly, for a lot of entities that are covered by HIPAA, HIPAA data itself is carved out of scope for New Jersey. But once that data is identified, typically the state laws also keep it carved out. Here, New Jersey said, no, we're going to actually not create an exemption for that as well.
Right, but didn't necessarily say the opposite. It's, in other words, you may be able to take the position that data that's been de-identified to the HIPAA standard is de-identified under New Jersey law. It's just that is more of a position as opposed to expressly stated in the law.
Exactly. There's just marginally more risk because in this case, the legislature didn't give their blessing in the same way that other states have.
All right. And now I think in maybe one of the most important components of the law itself is that this law did differ in providing an expanded role for the New Jersey Attorney General to promulgate regulations similar to what we've seen in California and Colorado.
Yeah, and this one is really going to be, I think, a thorny issue going forward because as we've seen from the California regulations and the Colorado regulations, this rulemaking authority gives them the authority to really run with the delegation that the legislature provided them. And we've seen states be really aggressive on this front. What it means is that reading the statute, it's not one and done in terms of the changes that you're going to need to make. You're going to need to be consistently watching to see what other pieces New Jersey also recommends or requires as part of that rulemaking.
Yeah, and I think we've already seen that with clients who are watching carefully the developments in California and Colorado. And unless I'm mistaken, I think New Jersey is only the third state to provide that rulemaking authority on a regulatory level as opposed to the statute and the legislation passed by the legislature.
Yeah, Scott, I think that's right.
So, Harsimar, maybe with the conclusion here, any kind of quick tips from your perspective on what companies should do now that we are anticipating that we're going to have that 13th or 14th data protection law in the place in the United States?
I would say difficulties reading the bill aside, it really does help to take a pass through. And if there are any positions that your organization particularly relies on, one that comes to mind is there's an exemption for directed disclosure under sales under a lot of the laws. There isn't that same exception here. it's really worth looking through and seeing if pieces that you've relied on in your compliance program still hold up under New Jersey, and start to incorporate some of those minor changes either across the program or specific to New Jersey residents.
And when does this go into force?
So it goes into effect a year after it's enacted. And so we'll have to wait until it's signed by Governor Murphy themselves. But 6 months after that effective date, there's also a requirement to start honoring opt-out requests through automated signals as well. So it's approximately 18 months is the total time frame we've got once it gets signed.
Got it. And importantly, it's not yet signed. Obviously, anything can happen. But as we are trying to stay out ahead of these issues, all sense is that we are now looking at a comprehensive privacy law in New Jersey.
Yeah. One thing I will also add is I know that there is another legislative cycle that has just gotten started with New Jersey. So there may be even further changes or amendments similar to what we saw with Virginia early on that may change even this bill further.
Okay. Last question is, the absence of provisions, I think, as many organizations worry about how these are going to develop, it sounds like there's been a few notable absences that we've seen in terms of exemptions and the directed disclosure. What about things like a private right of action that we've now seen creep into other laws?
So New Jersey has, I think, a special situation. The language itself or the bill itself doesn't affirmatively grant a private right of action. But one of the pieces that was taken out was language that specifically foreclosed a private right of action under other laws. And so what we may end up seeing is plaintiffs' attorneys using New Jersey's general consumer protection law and saying that a violation of this bill is a violation of that other statute, which does include a private right of action.
Interesting. All right. So we're not out of the woods on that one. And it sounds like there's going to be more creative positions that we may see from the plaintiffs' bar about how to loop in a private right of action under this law.
Exactly.
Harsimar, thanks so much for giving those quick reactions. I think we have a blog post up on the Chronicles of Data Protection, so you can check that out to read more. In the meantime, thanks so much for joining the podcast.
Yeah, thanks for having me.
I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.